That's okay?
Yeah.
Okay. Let me know if you get feedback. I can always go off mic. So I'm Kelsey Scarlett. As Tim, I'm getting a bit of a echo.
No, it's perfect.
Okay, I'm good? Okay. So I'm Kelsey Scarlett. I'm an attorney with Strickland and Goodwin. We represent the district in a variety of capacities. Today I'm here to give a presentation related to student investigations as well as bullying and Title IX. This is parent focused, so it's really, as Tim mentioned, supposed to give you a little bit of an insight on what the district is looking at when it's looking at investigations for students generally, but also some of the law relating to bullying and Title IX as well. So we're going to be covering 3 core topics tonight. Student discipline and investigation, so we'll be looking at common principles that are included in the district reviews and its investigations, as well as some of the protections that students are afforded generally in the investigation process, more related to discipline. We'll also be looking at Connecticut Bullying Law, so we'll both be first looking at the bullying law as it is now, so for the 2024-2025 school year, but we'll also be looking at it. I'll give you a bit of a preview for the 2025-2026 school year, which the legislation that we received in 2023 makes some significant changes to the bullying law, including the definition of bullying. So we'll first go through what bullying is now currently, if we had a bullying investigation or case, the definition that would be included here for this year, and then what it looks like for 2025. And then finally, we'll be looking at Title IX investigations and Title IX more generally. We are going to be focusing on the 2024 regulations tonight. I understand that some schools within the district are under an injunction. So there was a Kansas case that broadly enjoined the use of the 2024 regulations for certain school districts. I know that a school in Ridgefield is included in that, so while we'll be focusing on the 2024 regulations, just know that your student might, if hopefully not, the Title IX process comes up, they might actually be using the 2020 regulations because of that injunction. So I just want to say that from the beginning. I also like to include in this presentation just some key board policies that might be relevant to student investigation. So whether that be disability-based, harassment, and protected class-based, as well as bullying, the student discipline code, right, which might go beyond sort of harm, but relating to sort of some sort of violation of student conduct or student misconduct, and then sexual harassment, of course, related to discipline. So just like to include this, highlight it, just so you all are aware of some of the policies that are relevant to this conversation. So let's start with student discipline and investigations. Oh, and just before we dive in, something that Tim noted, I just want to reiterate, I will be accepting questions throughout this presentation. However, we have included some questions that are frequently asked by parents when districts are navigating these investigations or bullying or Title IX. So we'll talk about some of those questions, some answers to those questions as well, but I will be accepting and answering questions throughout this presentation. So let's start with student discipline, student investigations. Some people might think this acronym is slightly cheesy, but I think it's really helpful when we think about student investigations, right? And so here we're thinking about we're thinking about safety, umbrella, review, and end. So safety, the first step of this when we're thinking about student investigations is safety, of course, right? So depending on the underlying conduct of the allegation at hand, we might be, we're always reviewing safety and what concerns might be, what might arise based on the alleged misconduct or allegation. So for example, if we have a situation where the district is dealing with some sort of student-based bomb threat or, threat of gun violence, right? Hopefully that never happens, knock on wood, but if that were to happen, right, there's some immediate steps that the district would have to take, right? Of course, one of those things being contacting law enforcement, connecting with law enforcement. on the harassment side of things, right? When we think about safety, that might look like supportive measures, that might look like a safety plan. So first and foremost, when we get some sort of alert or put on notice of student allegations of misconduct, we're thinking about safety first and foremost. What do we accept needs to be taken, whether that's sort of party-to-party, student-based, or maybe a wide, sort of a district-wide response given the underlying allegations. The next thing we're thinking about is umbrella, right? So here we're really looking at and laws, regulations, policies that are being impacted. So we've sort of looked at safety, assessed safety. We're looking at the umbrella terms, the umbrella policies, of laws, regulations. And so depending on what the underlying conduct is, it might trigger specific policies, right? So if something is sex-based in nature, that might warrant, that might trigger the discrimination policy or sex-based discrimination policy. If something is related to bullying, right, that might also trigger requirements of the bullying. So we're both looking at policies that are related to the school, so student disciplinary policies, but we're also looking at state statutes, right? So there's a specific definition for bullying under state statute. There's a specific definition for sex discrimination under the 2024 10 regulations. So that's sort of the next step, right? What's sort of being implicated as a result of the alleged conduct? The next part really is the meat of the investigation that we're thinking about reviewing. So we're looking at the investigation. We're depending on what the underlying allegations are, the investigation might look different. We're sort of speaking to the right people, providing the student the opportunity to be heard, reviewing any sort of evidence that might be relevant to the specific allegations, and really just investigating whether or not this conduct occurred, right? And then finally, and we're thinking about sort of the remedies. So we've gone through the investigation, we've potentially put in some supportive measures or safety plan in place. We've reviewed our policies to see what else is implicated, which in turn could implicate the process in general that we're undertaking for the investigation process. And we've come to the end. So there's usually some sort of determination of whether or not conduct has occurred. If that conduct has occurred, reviewing the remedy, the appropriate remedy based on what has been substantiated. If conduct has not occurred, sort of also closing the investigation as well. And so I think when we think about the principles of an investigation the district is going to be implementing, we're thinking about be sure, right? That safety, umbrella, review, and evidence. And I think this umbrella piece sort of tripped people up because depending on what the underlying allegations are, certain policies might be triggered, and which might in turn necessitate a specific process, either federally or state-based or based on the policy that we have implemented on the level. Another important aspect of this, right, is looking at the purpose of the investigation. So here, an investigation may be pursued for a number of reasons, right? It could be a situation where we have a student who's just violated, not just, right? So bad. Who has violated a disciplinary policy in the district, right? Or we can have a situation where the underlying allegations relate to some sort of harm that was caused by student-student, employee-student, and so those are things that we're thinking about when we're thinking about what is the purpose of this investigation, what are we investigating generally, what's the conduct that's being alleged. And so this also includes, of course, bullying, as well as protected class discrimination and harassment. I think this can be seen as an obvious point, but I think it's an important point, right? There's no one-size-fits-all approach when we're thinking about student-based investigations. When we're thinking about student investigations, an investigation, right, investigations look at a lot of different things, depending on the underlying conduct and the allegations. An investigation could be one conversation with one student because the scope of things very specific or just related to the underlying allegations. However, there are instances where the underlying allegations are very complex, right? We're dealing with a situation that has multiple students who are allegedly harmed. We have a situation where we have multiple prospective respondents, right? The individual who's accused of being the perpetrator is, we have multiple respondents in a situation. So depending on the allegations, the scope of the allegations, what was alleged to have occurred, the investigation is going to pivot based on that information. And so I think it's just really important to remember that the investigation is not sort of, while there are key elements of an investigation, of course, right? I think it's really significant to know that the underlying allegations, it's really are going to sort of motivate how the district is investigating the conduct. I think this is really helpful just for me when I think about different cases that might arise, right? But I think it's also helpful to hear that no two things are the same, and so while one allegation or type of information misconduct was investigated a specific way, a different type might be investigated a different way. And while there's no one-size-fits-all approach when it comes to investigation, I think it is really important to also highlight, right, that there are some key elements as related to student protections and due process protections for students when we're navigating these investigative processes. So being prompt, fair, and thorough, right? And any sort of investigation, we're going to be thinking about those things in the district when we're thinking about how we want to move through this investigation. Being objective, of course, right? Being objective in the information that we're gathering and how we're reviewing that information, objective in the way that we're gathering that information between witnesses if that's required, or students, or the student that's alleged to have engaged in that misconduct. And just really being objective in our investigative process, but also in our decision making too, right? So that's a key element that we're going to be thinking about. Give the affected students an opportunity to be heard, of course, right? In some capacity, ensuring that the student has the ability to be heard. And that can look at a lot of different things based on the underlying conduct, right? And then finally, really ensuring that we're not prejudging the outcome and we're not rushing to judgment. We've done some sort of investigation. We've ensured that students' rights have the opportunity to be heard. We've objectively reviewed all the evidence, the testimony, the information that we have received, and we've come to some sort of conclusion, and that is not rushed. A common question we get in these sort of situations, right? Why can't I know what happened to another student that had a conflict with my child? Really significant here is FERPA, right? So FERPA is a federal statute relating to student education records and confidentiality of personally identifiable information related to students. That meaning sort of information that a reasonable person could connect to a student, right? So FERPA is a federal statute that we look at and it provides guidance and the framework for how we deal with it, how we interact with confidential student information. So for that reason, right, the protections that students are afforded under FERPA for confidentiality purposes, as well as for their student education records, we can't disclose that information to a third party without parental consent. And so there are these situations where, I've heard parents, really frustrated by the fact that they're not quite sure what happened at the end. They understand that there's been some sort of substantiation, but they don't get that additional information of what has happened to maybe the student that is the alleged perpetrator, right? And FERPA really is a reason why you're not privy to that information. So in the same way that you wouldn't want your child's disciplinary information or private confidential information being disclosed to another parent, the other parents are also afforded that same right. And so we get this a lot in any sort of investigation, but usually, when we think about the confidentiality piece, we're looking at FERPA, this federal statute. Another question that we tend to get as well is, can the district include restoration and disciplinary sanctions? Yes, right? Of course, the district can include restoration, restorative practices, principles when it's thinking about how it's going to engage in some sort of disciplinary sanction, right? And there, we're really looking at the underlying conduct, what has been substantiated, and whether or not a restorative practice might be an appropriate pathway. And when we're thinking about restorative practices, we're really thinking about sort of looking at policies or practices or, mechanisms that permit, that really go to the harm of that somebody has faced rather than punishment itself. So yes, of course we can include assertive principles, but that's absolutely going to be a judgment call based on the facts, based on the information that we received, based on what's been substantiated, and whether or not it's really an appropriate process or pathway for disciplinary sanction. We've talked a little bit about sort of generally what we're thinking about when we think about student discipline and investigations. I want to dive into the Connecticut Bullying Law. Sorry, keep on moving from the mic. In the Connecticut Bullying Law, I'm again going to focus on what the law is now, the definitions that are important for us to remember currently, as well as what needs to be investigated, and then I'll give you a bit of a preview for what's to come in 2025-2026 school year. We got another question. Can one unkind act be considered bullying? I hate it, but the lawyer we say it says it depends, right? So the alleged conduct must fall within the definition of bullying. It really depends. So in all of this, right, I think there's going to be a lot of gray area when it comes to investigations, but a lot of that comes from the fact that it's so fact specific, right? So it's really going to come down to the fact, the scope of the conduct, and the specific allegations, but it depends. It depends. We'll touch on what the definition of bullying is. So when we think about bullying in Connecticut, right, this comes from the state statute, this comes from our bullying laws on the state level. Bullying is defined as an act that is direct or indirect, right? Severe, persistent, or pervasive, I think that word is important, which causes physical or emotional harm to an individual, places an individual in fear of physical or emotional harm, or infringes on the rights or opportunities of an individual. So to our question, right? Maybe it depends. If it's falling under that definition, it might be bullying. But not every situation is going to rise to the level of bullying. Also, under Connecticut law, when we think of bullying, this definition also includes written, oral, or electronic communication or physical act or gesture based on any actual or perceived differentiating characteristics such as race, color, religion, ancestry, national origin, gender, sexual orientation, gender identity, or expression. It was a number of other protected classes, right? And so I think significantly here too is that when we think about bullying, right, I think we think of bullying as sort of separate from maybe other types of investigations, but there might be this overlap, right? Depending on what the underlying situation is, there might be, it might warrant an investigation in tandem with related to academics, right? Or so bullying, of course, can be investigated on its own, but given the underlying allegations, right, the purpose of the investigation, the alleged conduct of the investigation, spurring this investigation, it might also warrant bullying in conjunction with some other investigation as well. Of course, there's cyberbullying. I am sure you are all too aware of the, the implications of social media and how we're seeing that on the day-to-day. I know on my end as an attorney supporting districts, we see a lot of different types of acts that relate to student misconduct involving cyberbullying, involving social media, right? And so I think, of course, this is an important aspect of bullying and the bullying law that we want to be thinking about as well. So when we think about bullying, we're also thinking about cyberbullying, explicitly defined as any act of bullying using the internet, interacting with digital technologies, such as mobile telephone, or other mobile electronic devices. So again, really important here. I think it's also significant given that, cyberbullying due to social media can be pretty pervasive, right? It can happen outside of school, it can happen at home, and thinking about that as well. And so while you're sort of thinking about your students and their safety and on the sort of physical level, I think that electronic level, right, we're also thinking about too, that interaction with cyberbullying. Is every mean-spirited behavior bullying? No, right? So not every sort of situation is going to rise to the level of bullying. And I think it's really important to know those definitions of bullying and what may not qualify as bullying, and really that specific conduct has to rise to that level of bullying, has to meet those standards as outlined by our state statute. So sometimes conduct might not rise to that level of bullying, right? but it might be better addressed through a different form, right? Maybe it's not being addressed through the bullying investigation process, but maybe the school's general student discipline process. Maybe it's sort of an informal resolution process that you're pursuing a conversation with the two students, because it doesn't rise to the level of bullying, but it might warrant some sort of conversation between the families or the students. And in instances, of course, right, it could be a process that, maybe it doesn't get to bullying, or whether or not it does get to bullying, we're tapping into those restorative processes or principles or practices that might be appropriate given the underlying allegation. So, of course, right? Not every single mean-spirited behavior could be bullying, right? There's some things that students obviously should not say, should not do, but it might not rise to the level of bullying. That being said, there are other mechanisms, other pathways that we can address for that to ensure that students are feeling safe. When we think of bullying, right, we're thinking of there are instances where bullying must be investigated. So specifically on school grounds, right, we have conduct that is following that definition of, or potentially following that definition of bullying. If it happens on school grounds, if it's happening at a school-sponsored or school-related activity, whether or not on or off school grounds, then bullying must be investigated, right? Or put on notice of it, the district put on notice of this information, it has to investigate those instances looking like a field trip, right? Or some sort of, sports event that might be happening that's involving the district. So that the district still has the responsibility to investigate it if it could be potential bullying, right? At a school bus stop or a school bus, on a school bus or a vehicle related to the school. That is another instance, and of course through the use of electronic device or mobile device, at least are owned by the local board of education. So, for example, right, if you have a school-based computer that's used for cyberbullying, then we must investigate, or the district will put on notice of conduct that might fall into that definition of bullying, and if it's falling in these categories, then it must investigate it to see whether or not there is bullying. There are also instances where conduct occurs outside of school grounds, off school grounds, that might also, require the district to investigate. So these situations really relate to situations where the off-school ground conduct creates some sort of hostile environment in school for the victim, right? So maybe something started offline, but now it's becoming sort of something that happens that the student is facing at every single day at school, or they're facing at school in general as compared to maybe online. And so thinking about that, right, that's where we can potentially see that cyberbullying coming in. And infringes on the rights of the victim at school, or substantially disrupts the education process, or the orderly operation of school. So both on-campus conduct falling within that definition of bullying has to be investigated, as well as conduct that is outside of off-school grounds that falls within that definition of bullying has to be investigated. I think really importantly here too, right, there are instances where the district might receive anonymous reports of bullying. And I see that happen sometimes where, you have a family that doesn't necessarily want to attach the student's name to a report, but wants something to be done. I think it's important to also think about the requirements of the district when looking into these types of reports. So, of course, if the district receives some sort of anonymous report from a student relating to bullying, they of course have to investigate while still maintaining the student's name and identity as confidential as possible, as confidential, excuse me. And so this can be tricky, right? Because I think at times when you're while there's this balance on the district of wanting and needing to, in these situations, maintaining the confidentiality of the student, there's also limitations that come with that, right, when it comes to getting information and conducting a thorough investigation that to get additional information if you can't disclose that information. And so the investigation, of course, may be limited, right, as appropriate, given sort of the district needing to ensure that it's upholding the anonymity and confidentiality of that student. Anonymous victims should be informed of this from the start of the investigation, right? And we do that, right? The district ensures that and part of this too is to sort of for you all to understand too the limitations that might come with anonymous reporting as well, and that there's balance between ensuring that there's confidentiality of that student and it's upheld, but also the reality and the real implications and limitations to the investigation. Of course, it still needs to be investigated to the fullest extent if we have a bullying anonymous investigation, a report, excuse me. But I think really importantly here, I think sometimes parents don't realize this last point, no discipline may be implemented based solely on an anonymous report. So the district, of course, can take steps to ensure that there's confidentiality as related to a student if there is an anonymous report of bullying, conduct the investigation as thorough as it can to the extent that it's able to without disclosing that student's information, but no discipline may be implemented based solely on an anonymous report. So while the anonymous report is an option, of course, where that might be appropriate, or might be chosen as the best mechanism for the family and child, there are some obvious limitations to conduct an investigation when it comes to anonymous reports. All right. So everything that I just discussed relates to now, right? If we are talking about bullying for the 2024-2025 school year, that definition, as well as the scope of the investigation is related, as previously stated, relates to the 2024-2025 school year. We received legislation in 2023 that creates some significant changes to the bullying law in Connecticut. So, of note, it requires school districts to implement a method implement a new school climate policy and bullying complaint form. It redefines certain terms, right, including bullying, and it includes a new term called challenging behavior, which we'll touch on in the next couple of slides. It's updating the roles of the school climate personnel, and it's establishing new training and annual training requirements. And so I just want to say that, again, these changes that I'm about to go over are not current. If there were a bullying investigation that were to take place, we'd be looking at the definition that I just discussed. However, come to the school year for the 2025-2026 school year, these new definitions will be applied. Bullying, right? So we saw the previous definition of bullying. Here, in the 2025-2026 school year, bullying is going to be defined as unwanted and aggressive behavior among children in grades kindergarten to 12, inclusive that involves a real or perceived power imbalance, right? So we see the significant change here in the definition of bullying. I think I want to highlight really, that language of perceived power imbalance. And so I think that's language that we hadn't seen prior, right? So it's the language that we'll be looking at. But also, I think while perceived, there still needs to be some sort of evidence or some sort of documentation or testimony that goes to that perception, right? That still goes to that. So while there is that new phrasing, the district still needs some, school districts in general still need some sort of evidence or backing, whether that be testimonial or hard documents. But again, this is to come. This is not in place currently. Challenging behavior, right? So now we don't see this behavior, we don't see this definition, this new term is created under the 2025-2026 school year. Here we're seeing challenging behavior as related to bullying, right? And so that is defined as behavior that negatively impacts school climate or interferes or is at risk of interfering with the learning or safety of a student or the safety of a school employee. So I just want to highlight these things because I'd be remiss to sort of give you the tools to bullying and the definitions, but also not sort of alert you of what's to come in the pipeline soon. So those are just some terms that we'll be seeing next school year, but again, for now, the definition of bullying is as was previously stated. So we're going to talk about Title IX. Again, I just want to preface again that when we're talking about Title IX, I'm really going to focus on the 2024 regulations. As I noted at the beginning of this presentation, Title IX, the 2020 regulations for certain schools within the district might still be applicable, given an injunction that comes from the Sunstrong, Kansas case. So while I will be focusing on the 2024 regulations, just know that depending on your school, you might actually be navigating a Title IX process using the 2020 regulations. Title IX. When we think of Title IX, I think, it's really come to be a bit of a complex and, loaded, statute. So, but really, when we look at Title IX, the statute itself is not big, right? It's, less than 30 words. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance, right? And so when we think about Title IX, we're thinking about that piece on the basis of sex, right? On the basis of sex, what does that mean? How is that being interpreted? And what is sex discrimination being defined as under Title IX? We'll touch on that in the next couple of slides. Under the 2024 regulations, we're seeing an expansion in the definition of sex discrimination. So discrimination is including sex stereotypes, right? So stereotyping an individual solely based on their gender identity. The sex characteristics, right, really related to more of a physical, characteristic of an individual based on their sex at birth. Pregnancy or related conditions. We've always had protections in place for pregnancy and related conditions. The new 2024 regulations really explicitly state what to do with those situations if you do have a student that's pregnant. Sexual orientation and gender identity. So sexual orientation and gender identity, while new to the scope of Title IX, sex discrimination is not new to us here in Connecticut. We have fairly robust state-based statutes relating to including sexual orientation and gender identity within the definition of protected class, right? So our non-discrimination statutes related to schools, and just more generally in Connecticut, have included this and have had history of including sexual orientation and gender identity. So while this is newer to Title IX, this is what stage us in Connecticut here based on our state framework. Sex discrimination, right? So sex discrimination occurs when a person, because of the person's sex, is denied participation in or the benefits of any education program or activity receiving federal financial assistance. So this is a pretty broad term, right? When we think of sex discrimination, we're thinking about this umbrella type of, definition, right? And sex-based harassment is a form of sex discrimination. So some types of sex discrimination that wouldn't necessarily be sex-based harassment would be, for example, if you have a student that said, as a female student, I was discriminated against, and I was given, a B when my male peers were given an A. Right? That's not sex-based harassment, but it is sex discrimination, and it's falling under Title IX 2024 regulations. When we think of Title IX, I think a lot of the times we do go to sex-based harassment. So here, this is a form of sex discrimination. That means sexual harassment or other harassment on the basis of sex, including on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, gender identity. That is quid pro quo harassment, hostile environment harassment, and specific offenses. So when we look at quid pro quo harassment, we're thinking about this or that, right? So if you do this thing for me, I will do this for you, right? So a lot of quid pro quo really relates to an employee-employee relationship or a student-employee relationship. That power imbalance is included there. And a lot of times when I'm supporting districts, I don't see this one come up as much, luckily and thankfully. I do see, however, the second one, hostile environment, come up quite a bit. I think that one sort of has a bit of an amorphous definition when we think about hostile environment, what that means. And so we'll touch on that and pick apart the definition of hostile environment harassment. But quid pro quo, this or that, essentially the alleged respondent is making some sort of unwelcome sexual advance contingent on some sort of benefit that they're providing. And I forgot that I realized that there was another sign here, but yes. So here, again, we're thinking about quid pro quo harassment, a conditioning, some sort of benefit, some sort of service based on the individual's participation in unlawful sexual conduct. I think really importantly here as well, the alleged complainant's engaging in that unwelcome sexual conduct is not a factor in determining whether or not that quid pro quo harassment occurred. It doesn't matter whether or not the student engaged in that conduct. It just matters that they were put in a position of needing to engage in that conduct. Right? I think that makes sense. So when I think about supporting districts in the bulk of Title IX investigations that we conduct, I think about this definition. I think about hostile environment, sex-based harassment. And this is different than the definition that we have in the 2020 regulations. And when we think about the definition of sex-based harassment, this is really the meat of the change, I would say. I'm going to read this definition, and then I want to go back and pick apart some of the key points that are different. So when we think about hostile environment, sex-based harassment, we're thinking about unwelcome sex-based conduct that, based on the totality of the circumstances, is subjectively and objectively offensive and is so severe or pervasive that it limits or denies a person's ability to participate in or benefit from the district's education program or activity. This is a fact-specific inquiry. I'll highlight some of the key factors that districts will have to review when thinking about whether or not the conduct rises to the level of Title IX sex-based harassment, hostile environment. But when we look at this definition, I think there are a couple of key points that I want to highlight, right? Sex-based conduct, of course, must be under the sex. Based on the totality of the circumstances, right? So this conduct, we're looking, and this really goes for all types of investigations that the district is pursuing, right? It's fact-specific. We're going to be looking at the scope of the conduct, looking at the specifics of the conduct, looking at what's being alleged. It has to be subjectively and objectively offensive, right? So subjectively offensive to me is perceived as an individual, but also objectively offensive to the reasonable person who made both. And is so severe or pervasive, right? So objectively offensive and severe or pervasive. This is where we're seeing a big change between the definitions between Title IX and the 2020 regulations to now. Previously, it was under the 2020 regulations, it was objectively offensive and severe and pervasive, right? You needed all three. Now, under this definition, it's objectively offensive and severe or pervasive, right? Thinking about the severity of the conduct, but also thinking about the pervasive, how often is this occurring? And then fundamentally, it limiting or denying a person's ability to participate in the district education program, right? And so that can look like a lot of different things to a lot of students. It could be sort of that not, they're taking cuts to their attendance. They're no longer sort of participating or attending school. Maybe they're checking out and believe it's not meant to. Maybe they're no longer engaging in their extracurricular activities in a way that they have previously. I think that last piece really can present a lot of different ways, but we need all these different components to get to that level of sex-based harassment. And specifically, the 2024 regulations highlight some factors that must be considered when you're thinking about whether or not that conduct does rise to that level of sex-based harassment. And I think these different factors all make sense when we look at it, right? So first, the degree to which the conduct affected the complainant's ability to access the district education program or activity. When we look at Title IX, fundamentally, it's protecting the equal access of an individual to enter school and engage in their education program. So first and foremost, we're sort of looking at how has that been impacted by Title IX, or by the conduct, excuse me. The type, frequency, and duration of the conduct, right? Is it physical? Is it verbal? How often is it occurring? Is it once a week? Is it once a month? Did it happen once in the school year? The parties' ages, roles within the district education program, and other factors about each party that might be relevant, right? So the parties' ages are, of course, important, right? The conduct between two kindergartners is going to be seen differently as the conduct between two high schoolers, right? And so age is absolutely playing a role. The individual's role within the district, right? If they're dealing with a district employee, that's also going to play a role. Then also any relevant information about those parties. The location of the conduct and the context in which the conduct occurred is also significant, and then of course other sex-based harassment in the district's program or activity. So those are all factors that must be considered by the district when it's looking to see whether or not alleged conduct rises to that level of sex-based harassment. There are included in the definition of sex-based harassment is specific offenses, right? And one of those offenses that we tend to see a bit more frequently is sexual assault, specifically in the definition of sexual assault is fondling. So fondling, right, is the touching of the private body parts of another person for the purposes of sexual gratification without the consent of the victim, including instances where the victim is incapable of giving consent. So fondling, I see happen, next to hostile environment, I see fondling sort of come up a lot. And here, right, I've gotten, pose a question, what do you do in a situation where you have two kindergarten students, right, who are one doctor and then has been some sort of inappropriate touching? Well, here, that sort of kind of what rises to the level of fondling, given that it's not for the purpose of sexual gratification, obviously, kindergarten, that could rise to the level of purpose of sexual gratification. But I do like to just highlight this one subset of sexual assault as a specific offense, given that this is something that we tend to see in that K-12 range, specifically in the elementary range, more frequently when you still have students sort of, learning their bodies and learning to have their reasons. And of course, it's not an excuse for inappropriate touching, but just to say that conduct wouldn't necessarily rise to the level of fondling, but could be addressed, of course, under some sort of integrated mechanism or through a conversation. While we're here, I also just want to highlight some of the key elements of Title IX investigation. So when we sort of look back at the beginning of this presentation and think about sort of the purpose of the investigation, I think Title IX is one of those types of conduct that warrants and requires the district to have specific processes given sort of the regulations that are implicated and included for Title IX. So when we think of Title IX, we're thinking generally, right, under the 2024 regulations, there are a number of key elements to the investigation process that are particular to Title IX that I just want to highlight. So notice allegations. This is sort of, when there's the district is doing some sort of investigation, and there is some sort of notice to the parent, this is more of a formal, document or notification in the Title IX process. It's alerting both parties that an investigation is being pursued, as well as the scope of the allegations that are being alleged. Party and witness testimony. The party and parties and witnesses, if they've been identified or if you have relevant individuals who might have information related to the allegations, are permitted to provide and have the opportunity to speak, right? And that's sort of a staple, as we noted, of the investigation process when we think about some of the basics. But generally, when we see these Title IX investigations, there is that key component here of the party witnesses and testimony. And depending on the underlying allegations, what might be investigated, who's being spoken to might change, right? And given, a lot of times we have this person said this and this person said that, and witness testimony may not be warranted. However, if there are instances where another witness testimony is warranted, it might make sense to then interview other additional individuals. Evidence sharing, right? This evidence sharing portion is really unique to Title IX. So over the course of the Title IX investigation, you have an investigator who is conducting an objective investigation, of course. But over the course of that investigation, they obtain evidence. Sometimes that's their investigative notes, sometimes that's documentary evidence if you have, if they've received that. And there's an evidence sharing portion of the Title IX process. And so that essentially permits both parties to review the evidence that has been collected, all relevant evidence, I should say that, relevant evidence, right, relevant to the allegations, over the course of the investigation, review that evidence, and respond to it. And so that's a really unique aspect of the Title IX investigative process that you don't see in other types of investigations, but I do want to highlight that. And then, of course, there's a written determination, right? A written determination really outlining the facts that have been found, the specific definitions of sex discrimination that have been outlined and identified, as well as sort of the fundamental determination of whether or not there's been a finding of sex-based or sex discrimination generally. And so I do like to highlight this part, especially the evidence sharing portion, given that it's pretty unique to Title IX. And I think that sort of goes to the initial point of the purpose of the investigation, the underlying conduct, is really significant in the investigation that we're going to pursue in the process that we're undertaking. One final FAQ that we get, right, why are there different steps in a title investigation? Really, this comes down to the 2024 final rule as well as the 2020 regulations. Right? Those regulations identify, outline, and prescribe the process and procedure that the district has to undertake when it's reviewing potential kind of misconduct. And so that final rule as well as the 2020 regulations establish the grievance procedure that the district must undertake when investigating sex prevention. So I appreciate you all being here. Thank you all for, I know there's a lot of different things that you could be doing with your night right now, but I do appreciate you taking the time to, listen to this presentation. Thanks for having me.
Thank you. Appreciate the people who did come. We do understand, of course, we needed the rain badly, right? I know we needed it, but the only night that it seemed to rain is the night that we have parents coming into the building. But we do appreciate it. As we said, once we're able to get this and we have our fabulous tech people help us to kind of divvy up locators, we'll make this available so parents can take the time to go through it and look at it. Knock on wood, Jason, we've had a